Bylaws spell out everything from elections to finances to what kinds of businesses can operate in your building. Given the complexities of governing a condominium or co-op, boards often think of bylaws as one and done. But here's the rub. The world keeps changing and bylaws don't always keep up.
At the Folsom Group, our mission is to help boards make smart decisions every day. From end-to-end property management searches and construction project management to cost optimization, we help boards achieve sustainable savings, on-time projects, and long-term performance that speaks for itself.
I'm Carol Ott with Habitat Magazine, and today we're going to take a deep dive into what can happen when your bylaws lag behind the times. My guest today is Jennifer Miller, Managing Partner at J. Miller Law. Jennifer, thanks so much for being with us today.
Thank you for having me.
So you recently dealt with a case that really highlights why one and done is problematic. Your client, a condominium, had a commercial unit owner who wanted to open a cannabis dispensary, but the board didn't want that. Can you tell us what happened at this condo?
Sure. It was brought to my attention that the commercial unit owner was working through a process with its potential tenant to open a legal cannabis dispensary. In this day and age and in the news, you hear a lot about illegal cannabis dispensaries, but this is one that the New York State Office of Cannabis Management was offering a license to. And so we were faced with a predicament of whether or not this use group was permitted either at law or under the governing documents. And so this was a matter of first impression for me, because when the developers created the bylaws, especially in this building, they had actually been very thoughtful about thinking of certain uses that may be legal, but that they actually did want to prohibit. For example, restaurants, tattoo parlors, methadone clinics. But because cannabis was not legal, 20, 30 years ago, of course, they didn't have the wherewithal or the thought that perhaps this is something that we should prohibit.
So let me jump in here. First of all, when the board learned that the commercial unit owner wanted to rent to a legal cannabis shop, I guess the board didn't want that?
So for them, it wasn't so much the issue of cannabis. They really weren't taking a position on the legality of that and whether or not, the governor, whether politically that was the right thing to do. It was more of an issue of having this type of use in their building, which was primarily residential. The common area of their lobby that had an entranceway to their elevators had a shared space with the commercial unit owner.
I see. So that's actually the reason why the board got concerned.
Yes, there was concerns over that. There was a lot of children that resided in the building. And so New York State puts a lot of restrictions for cannabis dispensaries in terms of distance from a school. So the board and many of the residents felt the same way. If you can't be within 500 square feet of a school, why, for the same rationale, why should we have it within a building that has 20 to 30 children residing?
So just walk me through, boards are probably listening to this, but the process. So here's the commercial unit owner who wants to rent to this dispensary. Do they have to go to the board for approval?
Well, it really depends on your bylaws. So in this case, commercial unit owners and sponsor developers, when creating bylaws, they actually give a lot of rights to commercial unit owners to make that space more marketable and value. So, there isn't usually a requirement to provide notice about use. It's just usually a section in the bylaw. For example, the commercial unit may use it for any legal use except for XYZ. So, in this case, we found out about it because of the process of what is required under New York State in giving notice to the local municipalities.
I see. So if that hadn't been the case, the board wouldn't necessarily be in on the loop of who was going to be there.
That's correct. In this case, we saw it published because there had to be notification to the community board, and it got picked up by the local paper and the community. And there had to be a public hearing where the community board gave their opinion on whether or not they felt like a license should be issued by the Office of Cannabis Management.
And before we get back to this particular condominium, what did the community board say regarding this?
Yeah. So the community board was very much in agreement with the position that the board was taking. There's certain requirements to open a dispensary. For example, it needs to be on the first floor. Here, there was a step leading up to the commercial unit. They had concerns about other schools being in the neighborhood and whether that was in violation of the cannabis law. They had concern over ADA access in the building. In addition, they took note of all the residential makeup of the building and the shared lobby. So they did issue an opinion and resolution denying their support of this license for many of the reasons that we stated.
But in this condominium's bylaws, there wasn't teeth for the board to say this is a prohibited use.
Not explicitly, and that's what's really difficult because there was other provisions that, should we go to court that we would rely on. The question was, for example, the commercial unit owner or any unit owner must comply with all laws. The question then becomes, what's all laws? Is it federal law? Because under federal law, cannabis use isn't legal in the operation of a dispensary. But, that's difficult going to a New York court and asking them to rule against, the governor that's very much in support of this program. So that's a tough predicament to be in, whereas it's much clearer if we just had an outright prohibition.
And for most bylaws, what does a typical bylaw say about in regards to a commercial unit owner? I guess to any owner, what can somebody rent to and what can they not rent to?
Well, I think this was very eye-opening to me, given this circumstance. It really varies. That's why you really need to go back to your bylaws and review what are permissible uses. I've seen bylaw provisions or declaration provisions that just say any legal use. I've seen other provisions that say, any legal use, but XYZ. So it really can vary, and you can't just assume what can go into that space. So that's why it's important to look at this prospectively.
And what can a board do in changing their bylaws so that what can they do about this? So down the road, I don't know what might be out there that a building wouldn't want.
Well, it's a great question because it becomes difficult. You have competing interests here. You have a commercial unit owner that is more thinking about the building and its unit for economic reasons. Then you have a residential unit owners and that board that's thinking about more the community and life safety. Not to say the commercial unit owner doesn't care about life safety, but you very much have diverging interests in a mixed use building. So the issue is for the most part, when it comes to use, those provisions are set forth in your bylaws or declaration. And in order to change or update those, you're going to need a unit owner vote. At a minimum, 66 and 2/3, perhaps 66 and 2/3 percentage of common interest and number sometimes as well. But what becomes very complicated is that sponsor developers, when creating bylaws, oftentimes give a commercial unit owner a veto power, that you cannot amend that provision without getting their consent. So you're a little bit in a bind here. And that's really where you want to start thinking about your bylaws ahead of time. Is this an issue? Maybe you're on friendly terms with your commercial unit owner. Maybe your commercial unit owner doesn't really care and would never imagine thinking of having this in their space at this time. And so perhaps this is just a negotiation. For example, on that prohibited list, maybe it's prohibiting restaurants. Is a cafe a restaurant? Maybe you do a little bit of negotiation where you say, we can get our unit owners to vote to remove restaurants off the list if you'll agree to put a cannabis dispensary on there. Or is there something else that's restricted in the bylaws? Maybe something to do with alterations. So it's more about having that conversation with the commercial unit owner that maybe they will consent if you give them something in return. So it's really about being creative and strategic.
I see. So talk probably, hopefully will help, but a board would not be able to put something realistically in their bylaws that is sort of a firm line that can't be crossed.
Well, they could attempt to, whether they do it through a rule or a house rule or a policy, but it's very unlikely that that would be unenforceable. So it's best that they have these conversations early on, review it, and know what the potential and possibility is, especially if you're on good terms with your commercial unit owner.
So at the end of the day, what happened at this condominium? So the cannabis dispensary didn't locate in this condominium?
That's correct. At the end of the day, they weren't issued the license. There was whether, through all the support of the neighborhood, the whole entire neighborhood came to the community board meeting. The board really advocated with its unit owners. There was a lot of advocacy to the Cannabis Control Board to why this would not be a good location. So the tenant, never received the license, and, now it's being rented out to a new tenant.
I see. If you had one piece of advice for boards when it comes to their bylaws, what would it be?
My one piece of advice is you need to review it. I would say take a look at all these different provisions and talk to your attorney about it and see if there's any updating that can be done. I mean, the developer created many of these bylaws for buildings 20 to 30 years ago. Technology has changed, laws have changed, what is market has changed. And so you really just can't have this relic of a document that makes no sense. There's a lot of ambiguities in it. And I know that it might take a little bit of money and effort and time to update those bylaws, but I can guarantee you that it's a lot better than going into litigation over it.
Thanks. It makes a lot of good suggestions for boards. Jennifer, thanks so much for joining me today. That was Jennifer Miller, and I'm Carol Ott. Thanks for listening.
Thank you.